Hi, everybody who's there online. My name is Christina Duff. I'm one of the migration agents at Migration Services Pacific Centre, and I'm here to talk with you about the partner visa today, so the Australian partner visa. We will have time for some questions at the end, so feel free to send through any questions that you have to our online chat. I'll just check to see if everybody can see me by checking with our partners here. I can see some people who are saying hi. Hi, Camilla, in our Gold Coast office. We're just waiting for a few more people to arrive. I've been asked to introduce myself again. So for anybody who's recently arrived, my name is Christina. I'm a registered migration agent at Migration Services Pacific Centre, and I work from our Sydney office. Cool, so let's get started. So thank you for coming to our online seminar, and for people who are joining us later, thank you as well. So we're talking about the partner visa program, the Australian partner visa program. I know that there are a lot of Facebook groups about partner visas, but I do suggest not taking to heart any of the information that is provided on those Facebook groups, because I often find that those information pieces are incorrect, and we as migration agents need to clean up some of the messes from those Facebook forums. So let's get started on what is an actual partner visa and what is required for an Australian partner visa. So in the seminar, we're going to cover quite a number of pieces. So the onshore partner visa program and what that is, the offshore partner visa, the prospective marriage visa program, what you need to be eligible for a partner visa and how immigration assesses a partner visa, about the two-stage processing for a partner visa, bridging visas that you can get when lodging a partner visa, what you can do if you're still married to somebody else, what happens if your relationship breaks down. And one question that we're getting a lot at the moment is about the COVID travel waivers. If you can come to Australia, if you can leave Australia, and what the requirements are around that. Some people who we've spoken with recently might have an issue with a Schedule 3 and need a waiver. So I'll speak more about what is this and who has this issue. About sponsorship limitations. So if you've sponsored anybody else in the past, or if you've been sponsored for a partner visa, how you can include children in your application, and for people who have a visa refused in the past or a Section 48 bar. So I will explain this when we get to that section, so you can hold your questions there. And hopefully not too many of you would fall under this area, but for humanitarian sponsors and the Ministerial Directive 80, If you are one of the humanitarian sponsors and are subject to the MD80, I do suggest that you book a consultation so we can go over what you can do in detail. So let's get started. All right, so what is a partner visa? A partner visa is a specific visa that's made for Australian citizens, permanent residents, or eligible New Zealand citizens to sponsor their overseas partner, spouse, or fiance. So that could be husband, wife, de facto partner, or fiance. There are other visas that I've heard people call a de facto visa, which is where you might be adding yourself to your partner's student visa or temporary work visa. This isn't really a partner visa. So a partner visa is sponsored by one of those Australian citizens. So obviously we have an Australian citizen who is somebody who is an Australian citizen, permanent residents, or an eligible New Zealand citizen. So there are two essentially different types of New Zealand citizens in Australia. There's those who are already somewhat of a permanent resident called an eligible New Zealand citizen, and those who haven't yet obtained their Australian permanent residency. If you are a New Zealand citizen, or if your partner who wants to sponsor you is a New Zealand citizen, please book a consultation so we can see which sort of partner visa program you could come under, whether that be the Australian partner visa sponsorship or the New Zealand partner visa sponsorship, which is a completely different visa program. So to be eligible for a partner visa, your relationship needs to meet one of the following criteria. Either you're married, officially and legally married, or you've been living together for more than 12 months and you can prove it. So it's not so much about having lived together for 12 months, it's being about showing documents that you have been together for 12 or more months. And we will get into this. If you're not married and if you haven't lived together for 12 months, you can also apply under having your relationship registered, which only certain states and territories in Australia will permit. At the moment, it's all of them except for the Northern Territory and Western Australia. So you can register your relationship and you'll override the need to be married or living together. You can also be engaged. So this is for people who are outside of Australia only. It doesn't apply for people who are inside Australia. If you are in Australia and you want to lodge a partner visa, you can be engaged, but you would need to fall under sections 2 or 3. So living together or having your relationship registered. Immigration doesn't consider being engaged or periods of dating for the partner visa program. So all of these visas will let you stay in Australia, work here, enroll in Medicare, and apply for citizenship when you are eventually eligible. So first visa class, you might have heard all of these different numbers thrown around, the 309, the 300, the 100, the 820, the 801, the 461 for New Zealand sponsors. And it can get quite confusing about which visa that you want to apply for. So they go in 2 sections, or 2 go together. The offshore partner visa is the 309 and the 100. So the 309 is the temporary visa and the 100 is the permanent visa. When you lodge an application for a partner visa, you are lodging both applications at the same time, and your application will either go through a 1-stage or a 2-stage processing, which I'll get to later. So you're always going to be applying for the temporary visa, even though it is including the permanent one at the same time. So who's eligible for the offshore partner visa? Someone who is outside of Australia. So if you're inside Australia, you won't be able to apply for this one. And to be eligible for this, you have to meet the general requirements, which is married, living together for 12 or more months, you have your relationship registered, or you're engaged to be married, and you'll be married before a decision is made. So, for example, if you were planning on getting married next week, you could lodge that partner visa, and you would be married before a decision is made on the application. So this is one of the only times that you can be engaged, rather than meeting one of the other 3 requirements. But please do book a consultation with us about that, as they are being processed reasonably quick at the moment. So the prospective marriage visa is for people who don't meet one of those 3 criteria. So if you're not married, if you don't have your relationship registered, and if you haven't lived together for more than 12 months, you can apply for the prospective marriage visa, the subclass 300. This is for people who plan to marry inside of Australia. One thing to be aware of with this prospective marriage visa class at the moment is that once the visa is granted, these holders are not exempt from the travel restrictions to come to Australia. So you still need to meet one of the other 3 partner visa criteria to be able to access that travel waiver. So if you are one of the applicants who has got a subclass 300 visa, or if you have applied for this and you want to know what you can do about your process, I do suggest booking a consultation, because there are some complexities around this visa at the moment. So the onshore partner visa is the subclass 820, which is the temporary, and the subclass 801. Just like the offshore partner visa, these are lodged together. So you're lodging the permanent application at the same time as the temporary one. You'll go through a 2-stage processing, which I will explain a little bit about later. So you have to meet one of the 3 criteria, which is either you're married, you've lived together for 12 or more months and you can prove it, or your relationship is registered. So for people who can't prove that they have lived together for 12 or more months and they're not yet married, I would have that relationship registered. So people who have come to Australia on the prospective marriage visa, they are meant to marry inside of Australia and then lodge the partner visa once they have finished their marriage ceremony. So how does immigration assess the application? The general assessment criteria is, as we've spoken about before, married, living together, or relationship is registered. So if you're applying under the marriage criteria, you have to be married before your application is lodged. If you're applying under the 12 months living together criteria, you have to have been living together for 12 months before the application is lodged. So if you were lodging today, for example, the 27th of May, you would want to make sure that you have documents that are from before the 27th of May that show that you have been living together. Immigration can be quite strict on assessing the documents, so you really need to make sure that your application is at a high standard and consider either the marriage or the registered relationship if you do have concerns about your documents. So if you are engaged to be married, like we spoke about, this is only for people who are outside of Australia and haven't met one of the other criteria. You can also be engaged if you want to apply in Australia, but you may also have your relationship fall under one of the other 3 criteria. So how does immigration assess your application? Yes, there are those 3 main things that we've spoken about, but immigration goes deeper to make sure that it's not a scam marriage or a marriage of convenience just to get a visa. They want to have evidence that you are in a genuine relationship. So they assess this under something called the 4 pillars, which we call the pillars of the relationship. So the first aspect, and this is in no particular order, that is assessed under is financial. So usually when you are in a couple relationship, there's an element of financial sharing. You don't need to have a joint bank account, but if you do, that's great. That is good evidence. You need to be able to show that you have an element of financial responsibility for each other. So maybe you have a joint bank account, maybe you have separate accounts, but you share money and split that money into each other's accounts. You might have a joint lease together. You might have a joint mortgage together if you've bought a property. You could have your utilities bills under different names, so your gas, your electricity, your phone, anything that shows financial responsibility for each other. Sometimes that could also be the other partner paying school fees, which we have used in the past. So the social aspect is where you get to show all of your nice photographs together. So immigration wants to know that you present yourselves to the world as a couple. So this is where you can show things such as photographs together, showing your relationship story. You might have traveled together to different countries in the past. Perhaps this year it's only within your local area. But you can show things like your hotel bookings or your invitations to other people's events, birthday parties, Christmases, weddings, whatever you've done together. You'll also need to have 2 witnesses write a statement about your relationship, saying why they believe your relationship is genuine. So the household aspect, obviously this can be difficult for people who are not living together. So sometimes, particularly at the moment, there are couples that are separated just because they can't see each other in the other countries, particularly where we have clients who might be from war-torn countries such as Afghanistan or Iraq. It can be difficult for the partner, the other partner, to live together with them. So for the household, you need to prove that you have a joint responsibility for the household and what goes on in it. So this is all backed up by a written statement where you both write about these 4 pillars, and you would be mentioning who does the cooking, who does the cleaning, who takes out the garbage, who has the responsibility for making sure that the bills are paid on time, and generally what you do together as a household. You would also be wanting to show those documents that you are living together. So those documents, again, can be anything that has been mailed to you that shows your name, your address, and the date that it was sent to you is very important. I will mention again, under the social element, there are some relationships that are not recognized in certain countries, but it is still fine to lodge a partner visa if you can explain why you haven't told people or why you don't show people that you are in a relationship. So example would be some countries where there's same-sex relationships, but it's not acceptable in that country, or where there might be relationships between religions that are not accepted, or between different castes. It's still okay to lodge a partner visa, but you would be needing to explain why you're not showing yourselves as a couple to everybody else. The final aspect that immigration assesses is commitment. So not only do you need to show that you are in a relationship now and in the past, but that you have a long-term commitment to each other in the future. So this is where you go back to your relationship statement, so your written document that you've explained about your relationship, where you explain what your long-term plans are. So where do you see yourselves in 2 years, 5 years, 10 years, 20 years? You would also need to show your commitment, which can be a difficult document to provide, but things like a registered relationship or a marriage certificate or children of the relationship do show that you are committed to each other. You also need to show that your relationship is exclusive, so that you're not in a relationship with anybody else. So the 2-stage processing. This is where you've got the 309, the 100. Those applications go together, which is the offshore partner visa, and the 820, 801, so the onshore partner visa. So your application goes through a 2-stage processing, which is you first lodge the temporary application. Even though it's combined with the permanent application, you will still need to lodge a permanent partner visa 2 years after the temporary visa has been lodged. so long as that temporary visa has been approved. So for example, if you lodged your partner visa today on the 27th of May 2021, you would be able to lodge your permanent partner visa in 2023. You would need to first have your temporary visa approved before you can lodge that permanent stage application. The immigration fee is inclusive of both the permanent and the temporary stage. So when you do go to apply for your permanent visa in 2 years' time, you don't need to pay another immigration fee. So there are ways that you can skip this two-stage processing. So for people who had lodged a temporary visa quite a long time ago, there are people who have had their process in for almost 2 years or over 2 years. Immigration will know that, and they would be able to approve both the temporary and the permanent visa at the same time without you needing to apply for that second stage application. If you are one of these people who have been waiting quite a long time for your partner visa, if you wanted to be considered for that permanent stage, I would suggest providing some updated documents to your account so immigration can see that you are still in your relationship. So if you were trying to skip that 3-stage processing, you could show that you've been in a relationship for 3 or more years before your application is lodged. So that's not just a period of dating, that's showing that you are in a committed relationship for more than 3 years when you lodge the application. The other way is if you've been in your relationship for 2 or more years before you lodge the application and you have a child of the relationship. So when immigration goes to approve those applications, if you are removing the 2-stage processing, they would first grant the temporary visa and they would grant the permanent visa usually a minute or 2 afterwards. If you haven't been granted that, then immigration did not assess the 2-stage processing for the permanent visa, and you would have to either contact immigration just to clarify if you were considered for the permanent stage, or wait until you've been 2 years after your temporary application was lodged before you lodge the permanent stage. So again, we're just talking about the expedited processing, how you can get through that. One thing to take note of is that the prospective marriage visa holders, they go through essentially a 3-stage process because they have to first have their 300 visa approved before they travel to Australia and before they apply for their temporary partner visa, which then 2 years after they've lodged their temporary visa, if it's been approved, they can then lodge their permanent visa. So the bridging visas. If you lodge a visa in Australia, you will be given a bridging visa that's going to let you stay here while your application is processed. So your bridging visa stays sleeping until your current visa expires. So for example, if you have a working holiday visa and you lodge your partner visa today, your bridging visa is going to stay sleeping until your working holiday visa expires. If your working holiday visa expires in 1 month, for example, let's say the 1st of July, then at midnight, the 1st, 2nd of July, your bridging visa will activate and will let you to stay here whilst you're waiting for your partner visa process. There's a few different bridging visas that can be confusing for people. So we've got the A, the B, the C, the E. The A is the bridging visa that you're usually given if you hold a full visa. The bridging visa A lets you apply for a bridging visa B, which the bridging visa B is one that will let you leave Australia and come back during the processing time. So if you have lodged a partner visa inside Australia, you have to be inside Australia for the application to be approved. So if you're planning on leaving, whilst you have a bridging visa A, you should be applying for a bridging B before you leave so you can come back and still have the same work rights. If you do leave Australia without applying for your bridging B, or if you are already outside of Australia and have lodged a partner visa inside Australia and you don't have a visa to get back, you can apply for a visitor visa to return to Australia, and then you can reinstate your initial bridging visa. I do recommend booking a consultation so we can understand your exact circumstances. So if you apply in Australia whilst you have a full visa, your bridging visa will have full work rights. If you apply in Australia when you don't have a full visa, so if you have only a bridging visa, or if you have no visa when you apply for your partner visa, you'll be given a bridging visa C, and this one will not have work rights. You would need to apply for work rights based on financial distress. So if you are in that situation, please do contact us and we would be able to assess your ability and then make a claim with immigration. Another thing that you can be aware of, and again, please book a consultation, is that it is possible to get a bridging visa if you had lodged a visa outside of Australia in certain circumstances. So please, if you had lodged a partner visa outside Australia, do contact us because there are ways where you can get a bridging visa based on that outside Australia partner visa. The big question, what if you're still married to somebody else? Can you lodge your partner visa? So if you're still married to somebody else, you can lodge a partner visa. You would want to make sure that you go under one of the other criteria, which is that you have your relationship together, living for more than 12 months. So if you're married to somebody else, you cannot be married to anybody else. Your application would not be accepted. If you're married to somebody else, you should not be able to register your relationship because that shouldn't be able to go through. So if you are married to somebody else, you would need to make sure that you've lived together for more than 12 months and you have good documents to prove that before you lodge your partner visa application. You still need to be aware of the commitment assessment that immigration has. So you would need to show that your relationship with your previous spouse has ended and that you are trying to either finalize a divorce or going through the process. So the relationship breakdown. We do have the scenario regularly. Let me just take off my jacket. Where a relationship might break down during the processing of the application. So because there sometimes are long processing times with the partner visa, there are scenarios where the relationship breaks down between the lodgement of the application and when the application is assessed by a case officer. So when the application is assessed by the case officer, they want to know that you are still in your relationship for that visa to be granted. And that's all the way up until the decision of your permanent partner visa. So if your relationship breaks down, there's usually no way to have the visa granted unless you've fallen under one of these 4 criteria here, which is that you lodged your application inside Australia. So this provision is only for inside Australia applications, not for offshore applications. And you have either custody of a child that you had with your sponsoring partner, or your sponsoring partner died and you were still in your relationship at that time, or you or a family member experienced family violence and you were in your relationship at that time. So if you are somebody who has had your relationship break down and you think you might meet the criteria for the grant of the visa under the custody of a child, death of your partner, or family violence, please do speak with us, because there are some additional documents that you will need to show for these 3 categories. One thing to be aware of, that if you have had your relationship breakdown and you are on a bridging visa, and you don't meet one of those 3 criteria for your partner visa to still be approved, there are only limited visa options available, with the most common being employer sponsorship. So from a bridging visa A, it can be quite difficult or challenging to lodge another application. So for example, if you've been on your bridging visa A for more than 28 days since you last held a student visa, you cannot lodge another student visa. So that student process is off the cards. It's usually an employer-sponsored application that we would do instead. So visa refusals and the Section 48 bar. If you've had a visa refused in Australia and you haven't left the country, and you've come back, or you've stayed in Australia, and your substantive visa has expired, and you have either a bridging visa or no visa, then you are subject to what's called the Section 48 bar. This is something that prevents you from applying for most other visas whilst you're in Australia. So a common scenario could be somebody who had applied for a student visa or a graduate visa, and that visa was refused, and you've taken it to the AAT, and you're waiting for your AAT hearing. So we do have a lot of clients in this scenario, or consultations for clients in this scenario, and they are subject to the Section 48 bar, where they cannot apply for most other visas in Australia. It is still possible to apply for a partner visa in this scenario, but there are some complexities in this with the Schedule 3 requirement, which we will get to, that can make it difficult. If you've had a partner visa refused, so if your last visa refused in Australia was a partner visa, you unfortunately cannot apply for a partner visa again inside Australia unless you leave and come back with a new visa. So Schedule 3. If you're inside Australia and you don't have any visa, or you've had a visa refused and you're on a bridging visa, whilst you can still lodge a partner visa, you're going to be subject to a thing called Schedule 3, which is where you need to show to immigration that there's a very, very good reason why you didn't have a full visa when you lodged your partner visa, and that there's a really compelling, compassionate reason to grant your partner visa. So this is more to discourage people from applying for visas in Australia, having them refused, applying for a partner visa. Immigration prefers you to go outside of Australia and lodge your partner visa from outside, or to come back on a new visa. So if you are in the scenario where you have had a visa refused, or you're inside Australia with no visa, whilst it is possible to lodge a partner visa, they are more complex with the Schedule 3 criteria, where you need to have a very good reason why you didn't have a visa, and you still have a very good reason why your visa should be granted. We would be looking at the impact on your Australian sponsor if you were to have your partner visa refused. So what would happen to your Australian sponsor if you were not able to stay together? I suggest booking a consultation because they are complex and everybody's scenario is different. Again, we have people who are pregnant, but immigration does not consider pregnancy as a compelling thing. They only consider children after they've been born. So the COVID travel waivers. What can you do? How can you get here? Can I leave and can I come back? So partners of Australian citizens don't need an exemption to come to Australia if they hold a partner visa. So if you've applied for a partner visa and it's been approved and you're outside of Australia, you can come to Australia. That's no problem. You're exempt from the travel waiver. If you are in Australia and you want to leave and you are not a permanent resident of Australia, that's no problem. You can leave. So people who are on the temporary partner visas or who have applied for the temporary partner visas, they're one of the people who have the most freedom to leave Australia and return. So because you've applied for a partner visa or because you have that temporary partner visa, you can leave, you can come back, there's no problem. If you don't have a partner visa, then you need an exemption to travel to Australia. It's possible to come here on your visitor visa, on your student visa, on whatever other visa that you have, but you need to have a travel waiver approved. The travel waiver requirements for people who are partners of Australian citizens who don't have a partner visa are very similar to a partner visa application process. So you'd need to show those 4 pillars of evidence: the social, the financial, the household, and the commitment, to be able to have that travel waiver approved. It is possible to lodge a partner visa outside of Australia and apply for the travel waiver to come here, but there's no guarantee that the travel waiver will be approved if you're not showing those 4 pillars of the relationship. So sponsorship limitations. There are limits on how many people you can sponsor in your lifetime. So this is to avoid, I guess, to avoid overuse of the partner program, sponsoring somebody, sponsoring their sister, sponsoring their cousin, getting their whole family here, but just ending the relationship. Immigration wants you to prove that your partner visa is a genuine relationship. So they've put limits on the number of people you can sponsor in your lifetime. So if you are a partner sponsor, you're permitted to sponsor a maximum of 2 people in your lifetime unless a waiver has been approved. I'll speak more about the waivers in a moment. So if you have previously been sponsored for a partner visa, you need to wait 5 years before you lodge a sponsorship application, or before you lodge, your new partner lodges their visa application. So that's 5 years from when you lodged your partner sponsorship, or your partner visa rather, until your new partner lodges their Australian partner visa. 5 years needs to pass unless a waiver is approved. So reasons that a waiver could be approved is a child of the relationship, death of your previous sponsor or partner, or if there was family violence. There's also other reasons a waiver can be approved if there's compassionate and compelling circumstances that can affect the Australian sponsor. And again, I suggest that you book a consultation with us so we can assess your case. So including children in the relationship. You can include your children in the partner visa application. Firstly, one thing that you should consider is the cost of including people in the application, and if your child is already a possible Australian citizen. So if your child's parent, their mother or father, was an Australian citizen when the child was born outside of Australia, then the child can apply for citizenship by descent, and that will save you some of the immigration application fees, which is always nice. So you can include the children in the application, but when you apply, the children need to be in the same space as you. So if you're applying inside of Australia, all of the children need to be inside of Australia when you lodge that application. If you're applying outside of Australia, it should be the same. All the children are outside when you apply. So everybody needs to be either inside or outside Australia when it's lodged. You can't include adult children in the application. So if you have a child who's 30 or so, they're someone who's deemed to be responsible for themselves. So it's for children who are aged under 18 or over the age of 18 and they're dependent on their parent. So if your child has finished university, they've got themselves a job, they're already married to somebody else with children, they're not considered for your partner visa application. They would need to make their own process. If your child has a different parent to your sponsor, you would need to have the approval of that other parent for your child to be granted the Australian visa. So that's for children under the age of 18. If you were in Australia when you lodged your application and your child was outside of Australia, it is possible to sponsor your child for a visa later between the temporary and the permanent partner stage, or you could sponsor them for a child visa later once you have your permanent residency. So if you have children, please do book a consultation with us so we can see how you can include them in the application and timeframes that there might be. So children over the age of 18, again, they do need to be dependent on you. If the child is already married, then we can't include them. And if the child has already made their own way in life and is no longer dependent on you, we cannot include them. So the final one is the Ministerial Directive 80, and it won't affect many people. So this impacts visa applications, partner visa applications, where the sponsor arrived to Australia by boat seeking asylum before the 13th of August 2012. If you arrived after that date, it's likely that you would not have permanent residency and you would be on one of the temporary protection visas, which the temporary protection visa holders cannot sponsor their partners for an Australian partner visa. If you arrived before that date, you may have your Australian permanent residency, which means that you can sponsor your family overseas. But because of this Ministerial Directive 80, your family's application is going to be given the lowest order of processing unless a waiver is granted. So the lowest order of processing means that your family's application will continue to be put on the bottom of the pile as everybody else lodges their application. So the lowest order. There are applications that were lodged in 2013, for example, that are still being processed. If you are one of the sponsors whose family is affected by this Ministerial Directive 80, again, please book a consultation because it is possible to get a waiver. It is very difficult, but it's not impossible. So that's it for our partner visa seminar. If you have any questions, feel free to flick through any questions that you have and I can try and answer them now, or you can send an email to us or book a consultation. So I'll leave it open to you guys and my team to send me through any questions that you might have at the moment. I think the main takeaway to have from this is that when you are applying for a partner visa, please do take it seriously because you need to have a lot of documents to evidence your relationship. You can't just lodge with only a marriage certificate or only a registered relationship certificate or a photograph of an engagement ring. You need to show that you're in a genuine relationship, and you should also make sure that you meet the rest of the eligibility criteria and that you're not subject to any of those sneaky conditions like the Schedule 3, the Ministerial Directive 80, any bars, any previous refusals, previous sponsorships. Another thing that wasn't mentioned that should be aware of is that if your partner, your sponsoring partner, the Australian, has had any family violence convictions in the past or any serious criminal convictions, then that is something that you should speak to us about, because it can be difficult to have a partner visa approved in that scenario. The same with if the visa applicant has any major medical conditions or major criminal convictions, please do speak with us, because you must pass a medical exam and a criminal check for the visa to be granted. Cool. If you have any questions, please send us an email, drop us a line on our Facebook page, or I think we have Instagram as well. And you can always book a consultation with me and I can go over your application process. Cool. Thank you.